A very good morning to all the participants. Today is World Intellectual Property Day, and it is marked as the World Intellectual Property Day because today was the date of creation of the World Intellectual Property Organization. Intellectual property holds a very important place in this information technology era, and that is why Modern Law College has initiated the Innovatia, that is an IPR cell, since 2017. Under this, we have a lot of activities for sensitization of intellectual property protection, for support and mentoring of intellectual property registration, and any other information which is required for litigation or any other support which is required to any intellectual property holder. Under this, today we are organizing the information of intellectual property and importance of intellectual property protection through our Innovation IPR cell. At the outset, I thank Professor Dr. Gajanan Ekbote sir, the chairman of our Progressive Education Society, for giving us the opportunity to start the Innovatia IPR cell and to permit us to conduct activities under this cell. Today, we are going to have a basic discussion about the importance of intellectual property protection, and that will be done by one of our qualified trademark attorney who is also a faculty member of our law college, Archana Deshpande. I would request Archana ma'am to please start with her discourse.
Thank you, ma'am. Thank you, ma'am. I'm very grateful for organizing this lecture. It will definitely create awareness in the people about the IP protection. So thank you so much once again. I would like to share my presentation. Yes. Good morning to each participants. I'm Archana Deshpande. I would like to express my thoughts on the awareness about this intellectual property rights or the importance of this IP in today's world. This is the first slide which tells you there is a confusion between the people or in the understanding of the people about what are patents, what is copyright, what is trademark. So after completion of this session, each participant will definitely have a clear idea about कि patent क्या है, copyright क्या है, and trademark क्या है, and उसका protection करना कितना important है. So this question was asked, that is, can I patent my copyrighted trademark? So this will create a confusion. Okay, so to reduce this, to remove this hurdle, we'll move towards the next slide. That is, the intellectual property refers to the creation of the mind. It includes invention, it includes literary work, it includes artistic work, it includes designs, it includes different logos, symbols. In India, under the umbrella of intellectual property rights, we have patents, we have trademark, we have industrial designs, we have a copyright protection, we have plant varieties, we have geographical indication, and we have a layout design of a integrated circuit. So all these covers under the umbrella of intellectual property rights, and all these IP rights can be protected by different legislations. So when we consider this patents, trademark, geographical indication. So these all the offices are controlled by Controller General of Patents, Designs, and Trademark. So we have Patent Office. The main or head branch or head office is located at Calcutta, and other three branches are located at Delhi, Chennai, and Mumbai. Why I'm telling this? Because whenever there is a patent filing हो या फिर trademark filing हो, then everyone or the applicant should have a clear idea about the jurisdiction. The person who is residing in Pune uh, definitely will approach the Mumbai Patent Office. The person is residing in Punjab or in Haryana. That person will approach to Delhi Patent Office for filing the patent application. In case of design office, the main office is located at Kolkata. In case of trademark registry, we have five different locations. Head office is located at Mumbai, whereas the other branch offices are located at Delhi, Kolkata, Chennai, and Ahmedabad. Whereas the geographical indication registry is located at Chennai. And this copyright office is located at Delhi. Whereas this uh, semi-integrated circuit layout design के लिए आपको application करना पड़ता है to the Delhi patent Delhi office. Okay. Apart from this, uh, at the Nagpur we have Rajiv Gandhi National Institute of Intellectual Property and Management and Patent Information Service. So ये जो intellectual property offices जो है which are located at Nagpur, these offices cater users the needs on the basis of patent documentation होता है वहाँ पे, and they have a computerized system, so one can retrieve and one can disseminate the patent information patent office. Please mute yourself, Ruturaj Singhe. Please mute yourself.
म्हणजे हे का ऍसिड नाही तर काय म्हणताय फिनेल पाणी टाकले
Please mute yourself.
गरम पाणी टाकून असल्याशिवाय नाही जमणार ओके मला काय वाटतं गरम पाणी आणि साखर
Next slide.
थोडं घासून मुरावं लागेल हे सगळं
The first slide about the first this slide states about the or gives you the information about the patents. So when we consider this intellectual property rights, सबके दिमाग में सिर्फ एक ही word आता है कि भाई patents. It relates to the invention. So there is a difference between discovery and invention. So discovery means whatever you can easily found in the nature. But invention is nothing but it provides you a new solution, new technical solution to the problem. So patents में क्या होता है? So patents are nothing but the exclusive rights which are conferred to the inventor from the patent office for his or her product or the new product or new process. So generally these rights are referred as a negative rights. So when we consider the property, generally these intellectual property rights are the intangible rights. These are non-physical in nature, which derives the value from ideas or from the human mind. So in this knowledge age, intellectual property is a key to techno-economic growth. So ये जो इन्वेंशन है, जब पेटेंट एप्लीकेशन फाइल होता है और जब पेटेंट ग्रांट होता है, then patent office जो रहता है or under the patent act, the patentee is using or is having a monopoly over his creation, over his invention, to exclude the other person from practicing the invention. That is इन लीगल फ्रैटर्निटी हम उसको ये जो राइट्स कॉन्फर किए जाते हैं पेटेंट एक्ट से, तो उसको हम मौसी राइट्स बोलते हैं. दिस capital MOUSI stands for manufacturing the patented product, offering to sell the patented product, to use the patented product, to sell the patented product, or to import the patented product. So in case of product patent, we have a mousy rights. Whereas in case of process patent, we have offer to sell the rights, they sell the patented process, to use the patented process and to sell the patented process or to import the patented process. All these rights are conferred or given to the patentee or to the inventor. What now in case of patents, ये term of protection क्या है? So term of protection is for 20 years. So here we have Patent Act 1970 and Patent Rules 2003. So these 20 years can be calculated from the date of filing or date of priority date. So क्या है ये priority date? We'll see in the next slide. Before moving to the procedural part of registration or filing of any patent application, your invention should satisfy the none test. What is this none test? The N stands for novelty, this U stands for utility, and the last N stands for non-obviousness, or we can say it as an inventive state. So if the invention is satisfying all these three criteria, that your invention should be novel, your invention should have an inventive state, and your invention should have an industrial application, then such subject matter is referred as a patentable subject matter in India. We will see the patent filing process. So the person or true and first inventor has invented something. So after that, they have to carry out the patentability search. So this patentability search is carried out through Indian Patent Office. You can carry out the search regarding this patentability of your invention to check the patentability of your invention in the official website जो है. फॉर एग्जाम्पल यूएस पेटेंट ऑफिस का वेबसाइट है, यूरोपियन पेटेंट ऑफिस का इंस्ट्रेसनेट पेटेंट ऑफिस का जो वेबसाइट है, डेटाबेस है, या फिर इंडियन पेटेंट ऑफिस का जो है, इट इज फ्री ऑफ कॉस्ट चेकिंग. वहां पे वन कैन डन टू चेक द पेटेंटेबिलिटी. देन पेटेंट फाइलिंग होता है. पेटेंट फाइलिंग के लिए डिफरेंट फॉर्म्स यूज किए जाते हैं. तो फॉर्म नंबर 1 डील्स विद द form of application. Form number 2 deals with the provisional application or complete specification. यहाँ पे और एक पॉइंट है, if the person wants to file or the inventor wants to file the provisional application to fix the priority date. तो टू फिक्स द प्रायोरिटी डेट मीन्स कि भाई इसको पता है कि मेरा उन्होंने पेटेंटेबिलिटी सर्च किया है, आफ्टर दैट पेटेंट एप्लीकेशन के लिए फाइल किया है, बट दैट पर्सन और द ट्रू इन और द इन्वेंटर wants certain time period to carry out further invention. So that inventor will get a 12 months of time period to file the complete specification. So what is the difference between provisional application and complete specification? For complete specification में claims होना mandatory है, and it is not mandatory to include the claims in a provisional application. So provisional application से आप अपनी priority date fix कर सकते हो with the patent office. तो filing तो हो गया, फिर उसके साथ publication होता है. While filing your patent application, the inventor must submit the form number 9, which is for the publication, and form number 18 for the examination of your application. The publication होता है जब आपका 18 months का time period खत्म होता है from the date of filing of your application or the date of priority. Okay, आपका एप्लीकेशन ऑफिशियल जर्नल में पब्लिश होता है। फिर उसके बाद उसका एप्लीकेशन का चेकिंग किया जाता है और वन कैन से एग्जामिनेशन होता है बाय द पेटेंट एग्जामिनर्स। So patent examiners will generate the FER. It is post examination report. Okay. If the patent office or the patent examiner finds certain scrutiny, certain lacuna in the application, they will convey this lacuna to the inventor, or if the patent application is filed through the patent agent, all the communications will be made to the patent agent. तो FER जनरेट होता है, a specific time period दिया जाता है patent applicant को to remove, to reduce, to remove that objections taken by the पेटेंट ऑफिस एंड फिर उसके बाद पेटेंट ग्रांट हो जाता है। जनरली इन इंडिया इट रिक्वायर्स 3 to 5 years for having or for the grant of patent. Now I'm going to tell you certain examples, why I have taken or chosen these examples as an to explain you the importance of patent. So first एग्जाम्पल जो है और जो पेटेंट ग्रांट हो गया है वो है इम्प्रूव्ड स्टेपलर। तो क्या है ये इम्प्रूव्ड स्टेपलर? तो इट इन्वॉल्व्स द यूज ऑफ ए कलर पेन। तो यू कैन इजीली सी कि जो लास्ट वाली स्टेपलर की पिन है वो कलर्ड है। ओके, so it involves the use of color pins in the stapler, so it will indicate that the pins are finished. So this invention of the color pins is useful and it will prevent work disturbances. और जनरली क्या होता है, हम स्टेपलर यूज करते हैं और पिंस खत्म हो जाती है एंड विल गेट, हम इरिटेट हो जाते हैं कि भाई अब कैसे खत्म, मतलब अभी ये जो स्टेपलर के पिंस है खत्म हो गए। सो द लास्ट 3 पॉइंट्स क्या किया है इस इनोवेशन में, जो लास्ट 3 पिंस है ऑफ दिस बंडल आर marked red. So once the user comes to the end of the bundle, the color pins becomes visible and that user can easily replace the pin bundle immediately and continue the work. So it's a very simple example and इसको patent मिला है। Okay. Second है improved indicator. So ये जो improved indicator है कुछ नहीं है, simple problem था। और प्रॉब्लम जो है वो क्या था कि एक्सीडेंट्स होते हैं, छोटी जो व्हीकल्स रहते हैं तो उनका इंडिकेटर इजीली वन कैन नॉट रिकॉग्नाइज। तो इंस्टेड ऑफ दैट इनबिल्ट इंडिकेटर है ही उसमें। अपार्ट फ्रॉम दिस इन्वेंटर ने क्या किया, इन्वेंटर हैज यूज्ड एलईडी लाइट। So a big LED light has been placed on the top of the car to increase the visibility and ultimately to avoid the accidents. Why I have selected these two granted patents here? Because these patents have been granted to a 16-year-old girl. Okay. Then next, a few days ago, one article has been published in Sakal newspaper that this person, this 61-year-old engineer who is residing in Hadassar in Pune, has prepared this exercising machine. That this inventor has filed his application in 2016 and granted patents in 2023. So this inventor, now we can call it as a patentee, has prepared this exercising equipment. So everybody, those who are having their grandmothers in their home, initially we are using this machine to grind the millets, okay, wheat or bajra or jowari. Okay, all these we are used to grind in our home. Okay, so our grandmothers were used to use these machines at home. So this person has used the base of this and made up a exercising machine. So this machine can be used or useful for thighs, shoulders, forearms, then backbone. So for whole body, you can use this exercising machine. Uh, then next example is the Nasik-based trio or these boys. Uh, their company, everybody is watching or has been watched the um, this Shark Tank India season 2. This company has launched e-bike, naming the revamped Moto. They have a design patent. Also, they have filed the trademark, and the trademark has been accepted under class 12. So this scooter, this they have got the design patent over their this machine. So this scooter can turn into a mini store. So from when they said in this episode कि उनको पेटेंट है उनका उनको इस टेक्नोलॉजी के लिए उनका ट्रेडमार्क फाइल हो चुका है और उनको पेटेंट मिला है सो दे रेज्ड 1 crore for 1.5% equity from these sharks. Apart from this, there is one another example. Cuisines lab hai. They have also a patented technology. Uh, this technology has been used in case of checking the quality of fruits and vegetables. So they have their invention is mainly they have invented a machine, and this machine is mainly based on the Q-scan technology, and the result is having a 95% accuracy. So the machine which has prepared by that Cuisines laboratory is working on the spectroscopy, infrared, and artificial olfaction, which is featuring a sensor array. Okay. And this machine can easily evaluate the different odors from the fruits and vegetables. Okay. Apart from this, there are few examples of the granted patents. So weatherproof plastic pipes and method of making the same, an improved vehicle headlight device, audible medicine indicator, then system for conversion of agrobiomass and plastic waste into energy dense fuel, production of biofuels from waste plastic, a system for automatic segregation of waste materials, and automatic pink tea vending machine. So now reading all these examples or the previous examples which I have included in my slide, आप लोगों को ये पता तो चल चुका होगा कि भाई इन्वेंशन हमारे दिमाग में होता है बट हमको अवेयरनेस नहीं है हमको पता ही नहीं है या फिर हम सब लोग ऐसा सोचते हैं कि भाई इट इज वेरी डिफिकल्ट उसको पेटेंट मिला है और पेटेंट मिलना बहुत ही डिफिकल्ट है नो सिंपल सिंपल एग्जांपल्स है सिंपल सिंपल इन्वेंशंस है उनको भी पेटेंट ग्रांट हो चुकी है सो इट इज नॉट अ वेरी डिफिकल्ट टास्क तो दिस विल टेल यू कि भाई और ये जो है ये जो टाइटल है ये दीज आर द टाइटल्स ऑफ द इन्वेंशन ये इजीली एक्सप्लेन करता है कि व्हाट इज द सब्जेक्ट मैटर ऑफ दैट इन्वेंशन तो improved vehicle headlight device or audible medicine indicator weatherproof plastic pipe and the method of making the same the first one will tell you कि भाई ये यहाँ पे प्रोडक्ट भी पेटेंट हो चुका है और जो उसका प्रोसेस है to prepare that weatherproof plastic इसको भी पेटेंट मिल चुका है so in India we have a product patent as well as process patent. Now we are going to see the importance of the patent protection. So when we see the patent or the inventions which are granted patents, ये जो पेटेंट सिस्टम है it promotes the innovation, it promotes the invention. Second, it provides you the exclusive rights. It provides you the monopoly rights for a time period of 20 years. So within the 20 years, the patentee can exclude other people from using, from manufacturing, from selling that patented product or patented process. Okay. So the patent owner may decide who may or may not use the patented invention for that 20 years. Third advantage is the patent provides competitive advantage. So protecting the patent assets and rights may give a company the competitive edge over the competitors. क्या होता है? Exclusive rights grant होता है companies को. So company being a patent owner become a dominant player in a particular market. Okay, so this patent protection guards the owner's success from the hands of the competitors. Third, increase profit or returns. We have seen the examples of ये जो शार्क टैंक का जो नासिक बेस्ड रिवैम्प मोटो का एग्जाम्पल है. So these people raised 1 crore rupees for 1.5% equity. So ultimately they will increase the there is increase in profit, okay, and ultimately in the returns. So there is a potential financial return where patent owner may profit from its commercial exploitation. So there would be a typically increased returns and sales since competitors are barred from offering a similar product. Next importance is the additional revenue stream from licensing. Now, under the Patent Act, we have a provision of assigning your rights or licensing your rights. This licensing of your rights in case of Indian market is very important. Why? Because हमारे यहाँ पे एक कंपल्सरी लाइसेंसिंग का प्रोविजन है. क्या है ये प्रोविजन? ये जो बड़े बड़े जायंट फार्मा कंपनीज है जो मेडिसिन प्रोड्यूस करते हैं, तो उनका जो मेडिसिन कॉस्ट होता है वो बहुत हाई होता है. Everyone cannot afford these medicines due to the high cost. So in that case, our Indian pharma companies क्या करती है, उसका generic exclusive मतलब license लेके उसका generic drugs produce करती है, and this medicine will be available to the all the people, to all the patients at a reasonably affordable price. So additional revenue उस पेटेंट या वो जो जिसके पास उस पेटेंट ओनर को भी एडिशनल रेवेन्यू मिलता है फ्रॉम द लाइसेंसिंग. नाउ नेक्स्ट इज द टेक्नोलॉजी ट्रांसफर. So patent owners may transfer their patent rights to other companies or sell the patented inventions and get a one-time transfer payment in this exchange. So यहाँ पे the owner of the patent will no longer owner of this patent, but यहाँ पे technology transfer करके they can earn more money. Next is the new technology access through cross licensing. In this important point, if there are two companies who are in the same field and suppose उनके पास different patents हैं, they can make they can create or they can have a license with each other. They can on this patented product, and this there is a new access to the new technology through this cross licensing. Then next important point is the new market exposure. So a patent may also have a commercial value by for assessing to new markets through मतलब कंपनीज का मर्जर होता है, एक्विजिशन होता है, पार्टनरशिप करते हैं वो किसी और के साथ. तो they will have a new market exposure when there is a patent protection. I have already explained the increased valuation. So जितने भी पेटेंट्स ज्यादा रहेंगे कंपनी के पास, उनका पेटेंट पोर्टफोलियो बहुत पावरफुल रहेगा एंड दे विल हैव उसकी उस कंपनी की मार्केट वैल्यू ज्यादा रहेगी. ओके, सो टू इंक्रीज द वैल्यूएशन, पेटेंट प्रोटेक्शन इज वेरी essential and attract the investment. So the same example I would like to quote जो revamp motor का है. To attract the investments, the if your invention has been granted, आपको अगर पेटेंट मिला तो that company will attract the investments. Now next is the trademark. So in generally हम सबको पता है when we go to the mall हम ब्रांडेड क्लोथ्स को प्रेफरेंस देते हैं. तो दिस इज नथिंग बट द ट्रेडमार्क. इंस्टेड ऑफ बाइंग or purchasing local shoes, we can opt for the or we'll give the preference to Reebok, we'll give the preference to Adidas, we'll give preference to Nike and all these branded shoes. तो जब हम ट्रेडमार्क बोलते हैं, द ट्रेड एंड मार्क itself it gives you an idea, the mark which is used for trading purpose. So it may be a symbol, it may be a logo, it may be a word, it may be a color, it may be a design or a combination thereof. Okay, is used to identify a business or a product in commerce or service, serves to establish a goodwill and reputation in a product or service. A good trademark will be considered as it should not be a descriptive. आपका जो mark है, it should not be the descriptive or it should not describe your goods. It should not describe your service, which is going to be given by that company. When we consider this trademark, trademark की term of protection कितना रहता है? It is 10 years and it can be renewed for further 10 years. We have under Indian legislations, we have a Trademark Act 99 and we have a Trademark Rules 2002. ये जो तीन सिंबल्स यहाँ पे है मैंने इंक्लूड किए हैं. तो फर्स्ट इज फॉर द रजिस्टर्ड ट्रेडमार्क, सेकंड TM मीन्स अनरजिस्टर्ड ट्रेडमार्क, जब हम अपना एप्लीकेशन फाइल करते हैं, लेकिन हमारा एप्लीकेशन प्रोसेस में है, in that case this mark can be used. Okay, this symbol may be used before, during or without registration. ऊपर का जो मार्क है in circle R only can be used after the trademark registration, and SN stands for the service mark symbol. These are few examples of the trademarks. Now, when we see the types of the trademark, we have a product marks, we have a collective marks, we have a service marks, we have a certification marks, and we have a series mark. Apart from this, we have a well-known marks. Product marks, we can see कि कंपनी का जो प्रोडक्ट है उसमें कलर्स यूज किए हैं, कॉम्बिनेशन उसका कॉम्बिनेशन यूज किया है, नंबर्स यूज किया गया है, वर्ड्स यूज किए गए हैं, लेटर्स यूज किए गए हैं. Okay, all these the types of trademarks. Apart from this, we have a well-known marks. So what is the concept of well-known marks? Whenever there is a registration of trademark, जो ट्रेडमार्क रजिस्टर्ड हो चुके हैं, जिनका रजिस्ट्रेशन हो चुका है, उस ट्रेडमार्क का अगर इंफ्रिंजमेंट हो जाए तो उसके लिए रेमेडी दी गई है इन द अंडर द इंडियन ट्रेडमार्क एक्ट 19. But when known marks means what? Such type of marks which can be used for so many years. In that case, there is no essential to register these trademarks because these marks are already present in the market for so many years. तो अगर इन वेल नोन मार्क्स का इंफ्रिंजमेंट हो गया तो क्या रेमेडी है? सो कॉमन ला रेमेडी है, दैट इज द पासिंग ऑफ रेमेडी. ओके, सो these are the different types of trademarks we have. whenever we see the trademark, now you can see all these trademarks are not describing their product. So we can say the best example is the Apple. Apple का जो mark है, okay, Apple का जो it relates to computers. तो service क्या है तो computers, लेकिन it does not describe the goods or services which they are going to provide. So that is the, yeah, that means if your mark should be register, अगर आपका mark register होना है तो उसके लिए it should be fanciful, it should be arbitrary. Okay, so it should not be descriptive. So trademark infringement. So all these pictures will tell you कि भाई हम trademark, हम कोलगेट लेते हैं, हम कैडबरी खाते हैं, हम पेप्सोडेंट यूज करते हैं, इमीडिएटली ऑल द कलर कॉम्बिनेशन, उसका जो वर्ड्स यूज किए गए हैं हमारे दिमाग में तो फिट है, हम बिना रीडिंग करके बिना कुछ देख मतलब इमीडिएटली हम देख के ही हमको पता चलता है कि ये कोलगेट है, ये पेप्सोडेंट है, ये कैडबरी है, ओके। लेकिन whenever there is an infringement is nothing but the unauthorized use of trademark or the service mark. So there is a violation of exclusive rights attached to the trademark without authorization. So all these marks are causing confusion in the minds of the customer or in the minds of the consumer. Okay. So Adidas के तो देखो कितने पॉइंट्स है, Adidas लिखा है, दीदासा लिखा है, and all these. Okay. Then McDonald's का भी, it is a infringement. McDonald's, Glucose D, Glucon D, all these are the trademark infringement. So all these, the importance of this trademark filing is that no one can use your registered trademark without your permission, okay, without your consent. Now, our next category is the third IP rights under the umbrella of intellectual property right is the copyright and related rights. So what are the subject matter or copyrightable subject matter under the Copyright Act 1957? It is literary work, it is musical work, it is artistic work, it is dramatical work, it includes sound recording, it includes films. Apart from this, it also includes the computer generated work. So हमारे यहाँ पे under Indian law there is no concept of software patents, but we get the copyright over the software, okay, over the applications जब हम prepare करते हैं तो उसका हम copyright ले सकते हैं. Apart from this, we have a related rights. What are these related rights? The broadcasting organization rights and performance rights. So these are the copyrightable subject matter. What is not covered by the copyright? Ideas, facts, recipes, the work which is lacking originality. Yes, जैसे हमने patents में देखा कि your invention should be novel, your invention should have a inventive state, your invention should have a utility. Similarly, यहाँ पे the very important word is the originality. So all these your work should be original. So names, titles और short phrases का हम copyright नहीं ले सकते. What is the term of protection in case of copyright? Generally, it depends on the nature of the work or the owner of the copyright and whether the work has been published or not. But general rule is 60 years. So in case of literary work, musical work, artistic work, it is 60 years from the death of the author. Okay. Generally, lifetime of the author उसको copyright मिलता ही है and the 60 years from the death of the author. Generally, हमारे यहाँ पे Indian legislation में it is not mandatory to register your copyright. Why? Because when your ideas get expressed in any form, it gets automatic protection. But if to avoid further legal consequences, कुछ complications हो गए बाद में, तो अगर आपका वर्क जो है अगर वो कॉपीराइटेड है, उसका अगर प्रोटेक्शन आपने लिया है, अगर उसका रजिस्ट्रेशन आपने किया है with the copyright office, then it can be considered as a legal proof. Okay, valid proof of that certificate of registration is considered as a valid proof. Then, in case of films, in case of sound recordings, in case of photographs, in case of posthumous publication, in case of anonymous or pseudonymous publication, in case of work of government or work of international organization, it, it is the same. That is 60 years from the date of publication. In case of broadcast organization को rights है, these rights are 25 years from the first publication. Whereas performance rights जो होते हैं, जो actors रहते हैं, jugglers रहते हैं, all these include the और उनको term protection दिया गया है 50 years from the end of the year in which the performance was fixed or it took place. Okay. There are certain exemptions. Sometimes we can use this copyrighted work without authority or without permission of the copyright owner if it is used for the purpose of research, if it can be used for the private study, it can be used for teaching purpose, it can be used for criticizing, or it can be used, it is related to the judicial proceedings, or it can be used for making sound recordings, but all these conditions may or एक essential conditions है that person जो ये use कर रहा है without the permission of the copyright owner, that person should not own something, that person should not have a financial benefits from using such a copyrighted work. Then it can be considered as a fair use. Now, next is the geographical indication. This geographical indication, the very best example is the Puneri Pagdi. So, kya hai? This geographical indication of the goods or the uh, it tells you or it signifies you, it provides you the information uh, about the original location of that product, or it gives you the it provides you the quality of that product, or it provides you the it gives you the information about the reputation of that product, it gives you the idea about the characteristic of that goods, and all these quality, reputation, or characteristic of the goods are essentially linked with the or attributable to the origin कि भाई वो product कहाँ से है. The example is the Alfonso mangoes. These are grown in the Konkan area. So geographical indication covers under the Geographical Indication of Goods Registration and Protection Act 1999. Okay, so this example is that Odisha Rasgulla को ये geographical indication का certificate मिला है in the year 2018. And the term of protection is 10 years and this can also be renewed. So there are few examples of Indian geographical indications, that is basmati rice, Mysore silk, wood orange, Madhubani painting, and it covers not only the agricultural products, it also includes the manufactured products, it also includes the synthesized products also. Okay, so Tirupati laddu, Kolhapur chappal, then Alfonso mangoes, Dharwadi peda, all these includes the covers under the geographical indication. So what is the importance of protecting the GI? So यहाँ पे और एक concept है registered user. If you see the patent, if you see the copyright, if you see the trademark, these are sole rights है, okay, individual rights है. But यहाँ पे जब हम GI प्रोटेक्शन करते हैं तो यहाँ पे रजिस्टर्ड यूजर होते हैं, ओके. So it gives the benefit about it confers the legal protection. It prevents the unauthorized use of registered GI. It promotes the economic prosperity. It boosts export of that goods. Also, it serves as a source identifier to the consumer. So these are the benefits when there is a GI protection. And what is the impact on the developing countries? Ultimately, when there is a GI protection number of, and all you are knowing that India is having a biological diversity, or India is a biological diverse country. So it facilitates the market access, it encourages the rural development, it saves local natural resources, and it plays important role in the preservation. Okay. जिस जो प्रोडक्ट जहां से आता है इट विल उसको एक नई पहचान मिलती है व्हेन देयर इज अ प्रोटेक्शन अंडर द जियोग्राफिकल इंडिकेशन. नेक्स्ट इज द इंडस्ट्रियल डिजाइंस. तो क्या है ये इंडस्ट्रियल डिजाइंस? It constitutes an ornamental or aesthetic aspects of an article. Now you can see this is a bottle. ये इसका जो shape है हम easily understand हमको पता चलता है. Okay? हम we can judge it solely by our eyes. Okay? ये हमारा फोन है या फिर अब जो नए फोन आए हैं जिसका स्क्रीन बहुत बड़ा होता है. ओके. सो दीज आर द डिजाइन्स. दिस शार्प ये जो नासिक बेस्ड रिवैम्प मोटो है तो उनको भी डिजाइन पेटेंट मिला था ऑन द जो डिजाइन उन्होंने अपने व्हीकल में बनाया है उसके लिए. इट कम्स अंडर द इंडस्ट्रियल डिजाइन. सो इंडस्ट्रियल डिजाइन may consist of a 3D feature such as shape of an article. It may be a 2D feature such as patterns, lines or colors. तो यहाँ पे भी जो finished article है it can appeal to your eyes and it can be judged solely by the eyes only. The term of protection क्या है? Similarly यहाँ पे 10 जब इंडस्ट्रियल डिजाइन पेटेंट जब मिलता है तब टर्म ऑफ प्रोटेक्शन रहता है इनिशियली 10 years of time, 10 years of time period के लिए, and it can be renewed for further 5 years. And the legislation is Design Act 2000 and Design Rules 2001. These are the few examples of in the लेफ्ट हैंड साइड जो फर्स्ट एग्जांपल जो फर्स्ट फोटो है इट इंक्लूड्स ये एक गिफ्ट है. ओके. मतलब एक आर्टिकल है उसमें हम चॉकलेट्स रख सकते हैं. सेकंड है इट इज अ different shaped bottle. The third is the lunch box. It is a combined lunch box. It also attached with a bottle. So it is a unique design. And the next is the it is a tablet. डायनापर टैबलेट. जनरली टैबलेट्स आते हैं वो राउंड शेप में रहते हैं या फिर ऐसे सिलिंड्रिकल रहते हैं. बट दिस डायनापर टैबलेट इज डी शेप्ड टैबलेट. सो ड्यू टू दिस the importance of this design protection is your product looks attractive or so the customer it appeals to the customer easily. So it can be your USP, your unique selling point. You can, whenever there is a design protection or a design patent, if you have, you can protect against copying and infringement. Also, it adds value to your product. You can have a fair return on the investment and you can build a business assets out of the protection. So this is the importance of design protection. Next is the semiconductor integrated circuit layout design. Generally, we can refer it as a chips or microchips. These are the electronic circuits in which components like transistors, diodes, or resistors have been assembled on the surface of a thin semiconductor material. So whenever there is a registration of this semiconductor integrated circuit layout design, it should possess the characteristic of originality. It should be distinctive. It should not be commercially exploited, and it is designed to perform an electronic circuitry function. So यहाँ पे भी term of protection है 10 years. The last category is the Protection of Plant Variety and Farmers' Rights Act. This act confers the right to the breeders, researchers, and farmers over their plant varieties. So this act gives you an effective system for the protection of plant varieties. It will help to recognize and protect the rights of the farmers in respect of their contributions made at any time in conserving, improving, and making available plant genetic resources for the development of new plant varieties. So in Patent Act, हमने नॉन पेटेंटेबल इनोवेशंस का मेंशनिंग किया है. वहां पे जो है इट आल्सो इंक्लूड्स कि हम जो प्लांट्स है एज अ होल और प्लांट इन पार्ट वी कैन नॉट register it as a patent, or we cannot take the protection under the Patent Act. तो प्लांट वैरायटी जो ब्रीडर्स है, जो सीड्स से रिलेटेड जो राइट्स है, which we have under Indian legislation, we have a Plant Variety and Farmers Rights Act. Up to this Plant Variety Act under Indian legislations we have, but ट्रेड सीक्रेट का देखा जाए तो ट्रेड सीक्रेट के लिए हमारे इंडिया में there is no any specific law for it. It comes under the Contract Act. But if you see the trade secret, the 7 must of the trade secret, it must be kept secret. It must be documented. It should have a limited access. It must be protected using administrative, legal, and technical means. It must be of the value of the organization now and in the future. It should not be in the public domain, and it must have an appropriate legal framework in place if it is shared with the other. So these are the examples of famous trade secrets. So the formula of Coca-Cola, the formula for this sauce, which is used in the McDonald's burger, KFC chicken recipes, and this WD-40 formula. So these are the examples of trade secrets. Now I'm going to share with you certain fact sheets. These fact sheets I have taken from the website of the World Intellectual Property Organization. These will also gives an added point or added अंडरस्टैंडिंग कि भाई पेटेंट हो या कॉपीराइट हो या ट्रेडमार्क हो, उसका प्रोटेक्शन करना कितना इम्पोर्टेंट है. ओके, सो इफ यू सी द दिस पिक्चर, यहाँ पे हमको ये दिखाई देता है कि more than 85% of all the patent filings in the year 2021 occurred in the Patent Office of China. फर्स्ट नंबर 1 कौन है? चाइना, फिर उसके बाद है यूनाइटेड स्टेट्स, फिर उसके बाद है जापान, फिर उसके बाद है कोरिया, एंड द 5th वन इज द यूरोपियन पेटेंट ऑफिस. सो यहाँ पे चाइना अकाउंटेड फॉर 46.6% ऑफ द वर्ल्ड टोटल. सो अगर वर्ल्ड पेटेंट एप्लीकेशंस देखा जाए तो चाइना is placed at number 1. This picture tells you about the China. वो तो हमने ओवरऑल पेटेंट एप्लीकेशंस कितने किए वो देखा. This will tell you कि भाई चाइना का जो पेटेंट ऑफिस था वहां पे कितने पेटेंट एप्लीकेशंस फाइल हो चुके हैं? सो 1.5 मिलियन पेटेंट applications has been filed with the Chinese patent office. उसके बाद है यूएस, उसके बाद है कोरिया, उसके बाद है यूरोपियन पेटेंट ऑफिस। एंड आई एम वेरी ग्लैड कि यस, इस टॉप 10 में इंडिया का भी नाम है। So the top 10 offices accounted for 91.6% of the world total in 2021. So there is an increase of 8.5% increase in the filing of patent applications in Indian Patent Office. When we see the trademark filing, word trademark filing activity, when we consider, there are total, its number is too high, 65%, 65.4% of all trademark filing activities has been carried out in all classes. यहाँ पे भी टॉप 1 है, टॉप में है चाइना, फिर यूएस पेटेंट ऑफिस, देन ईरान, then European Union Patent Office, and then India. So China alone accounted for more than 52.1% of global trademark filing activity, primarily from Chinese residents. These are the numbers which gives you idea about चाइना का जो पेटेंट ऑफिस है, चाइना का जो ट्रेडमार्क ऑफिस है, उनके पास कितने एप्लीकेशंस रिसीव हुए हैं? 9.5 मिलियन classes were specified, and it was followed by the US trademark office, then Iran का trademark office है, फिर उसके बाद European patent office है, that means trademark office है. Okay, so these are the, now you can understand in case of patent filing हो या फिर trademark filing हो, China is placed at number 1 पोजीशन. ओके, उसके बाद यूएस है, उसके बाद यूरोपियन यूनियन है. ओके, सो ऑल दीज विल कवर और विल गिव यू एन आइडिया कि भाई इंडियन पेटेंट हो या कॉपीराइट हो या फिर ऑल दीज आईपी एसेट्स हो, दिस इंटेंजिबल एसेट्स हो, उसका प्रोटेक्शन करना कितना इम्पोर्टेंट है. सो व्हेन यू क्रिएट समथिंग and file your application, it will get protected. It will get protected by the patent office ho ya trademark office ho. It will ultimately leads you to the successful, or it will result into a successful business. So uh, if if you are not protecting your IP assets, you could use the opportunity to commercialize your invention. Uh, uh, the second consequences will be your competitors would gain advantage over you. So, to establish and maintain the rights to protecting your invention, in turn, it will become a valuable assets of your business. If you protect your IP assets, it definitely avoid the costly mistakes. If there is an infringement will takes place, the infringer will be awarded with the damages. एंड जो पेटेंटी है, जो ट्रेडमार्क ओनर है या फिर कॉपीराइट ओनर है, तो उसको अल्टीमेटली जो लॉस हुआ है ड्यू टू द इंफ्रिंजमेंट, उसकी भरपाई उसको मिल सकती है. सो इफ देयर इज पेटेंट और कॉपीराइट हो या ट्रेडमार्क हो, इफ इट इज नॉट प्रोटेक्टेड, वहाँ दिस कैन बी एन इंफ्रिंजमेंट हो गया, तो उसको हम कॉस्टली मिस्टेक हम बोल सकते हैं. ओके, एंड the third is the IP rights. These rights can be assigned to the other party. Your rights can be transferred through licensing, and in previous slides we have seen कि भाई each IP के लिए, each patent के लिए, copyright के लिए उसका importance क्या है. Okay, to copy something without the authorization, उसका legal consequences क्या हो सकता है, वो कैसे harmful है if you are not protecting your IP. So this will give you a clear idea. This session is specifically arranged to make to create awareness in the people about the intellectual properties we have and the importance of IP protection. So any doubts or any queries regarding this? So you can unmute yourself and you can ask me if you have any doubt.
Thanks, madam. It was very informative.
Thank you, sir. Thank you for your prompt reply.
Thank you so much.
Any doubts?
Hello, ma'am.
Yes, please.
Ma'am, I'm LLB third year student.
Okay.
And my question is, what will be the role of latest AI engines like ChatGPT and all? Would it be affect the IP sector, or it just, or we can absorb the AI technology through the more adaptable IPR, more adaptable intellectual property?
Could you please repeat your question because I couldn't get it fully.
Ma'am, I will type the message
Okay.
actually
Please.
because I think range problem is there.
Yeah. And some noise is coming from your side. So I could not get
Yes, ma'am.
you.
Sorry for that.
You are from the LLB third from the Modern Law College?
Yes, ma'am. Yes.
Okay, so you can meet me personally and you can ask me whatever you have, whatever the doubts you have. Any other questions relating to this? Because our Innovatia cell जो है, Innovatia IPR cell है, you can, if you have any doubt, if you have any query regarding intellectual property rights, हमारा Google form है, हमारा online, you can go to the Modern Law College website, वहाँ पे भी एक Google form दिया गया है, and you can raise your query over. Or you can write your query and you can submit the Google form. Any other question or should I end the meeting? Yeah. I think I should end the meeting.
Thank you, ma'am. It was a very nice and informative session. And I really feel that we have achieved something positive by taking up this activity on the World Intellectual Property Day. I wish all the participants thank you very much. I offer my sincere thanks and regards to our Progressive Education Society, the chairman, secretary, our coordinator, Dr. Gajanan, our coordinator, advocate Dr. Chintamani Ghate sir, and all the staff members for taking up this activity and making it a successful one. Thank you, one and all.
And thank you all the participants for patiently listening.
Thank you very much, ma'am.